A federal court just issued a ruling that could wipe out rifle feature bans across the entire country, and the Department of Justice in 20 states are standing right behind it. Quick question before we continue. Are you subscribed? Because what I'm about to break down could be the most important gun rights development you've heard in years. We're talking about a decision that affects millions of gun owners right now, today. If you care about your rights and your rifles, hit that subscribe button before we go any further. I don't want you missing the follow-up. Videos that explain exactly what this means for your state and your specific situation. Okay, let's get into it. Here's what just happened. A federal court handed down a ruling that directly challenges the constitutionality of rifle feature bans. Now, if you've never heard that term before, don't worry. I'm going to break it down in plain English right now. Rifle feature bans are laws that target specific physical parts of your rifle. Things like pistol grips, adjustable stocks, thumbhole stocks, flash suppressors, and forward grips. These laws don't ban the rifle itself. Instead, they say you can't have a rifle that has certain features. California, New York, New Jersey, Massachusetts, and a handful of other states have these kinds of laws in the books. The idea behind them was to make so-called assault weapons harder to define while still restricting them. So instead of banning a rifle by name, lawmakers said, if your rifle has 2 or more of these features, it's illegal. That's been the law in several states for decades. And millions of gun owners in those states have had to either give up their rifles, modify them in awkward ways, or buy special compliant versions that look and function differently. Some people even move to other states just to keep their legally purchased firearms. That's how serious this has been. Now, this court is saying those laws may not be constitutional at all. Here's why this ruling is such a big deal. After the Supreme Court's 2022 Bruen decision, the legal standard for evaluating gun laws completely changed. Before Bruen, courts would ask whether a gun law was a reasonable regulation. That gave states a lot of room to pass all kinds of restrictions. But after Bruen, the Supreme Court said that's not the right question anymore. Now courts have to ask whether a gun law is consistent with the historical tradition of firearm regulation in America. In other words, did people in 1791, when the Second Amendment was written, have laws like this? If the answer is no, the law probably doesn't pass constitutional muster. And here's the thing. There is no historical tradition of banning specific rifle features. There were no laws in the 1700s or 1800s that said you can own a musket, but only if it doesn't have a certain kind of grip. That concept simply didn't exist. So under the Bruen standard, feature bans are on very shaky legal ground. And now a federal court has said exactly that. But here's the crazy part. This isn't just one judge in one small district taking a wild swing. The Department of Justice itself and 20 states have filed in support of the legal challenge to these bans. Think about that for a second. The DOJ, the federal government's own legal arm. They are backing the argument that rifle feature bans are unconstitutional. That is not a small thing. When the DOJ takes a position like this, courts pay attention. And when 20 states line up behind that position, it sends a signal that this is a serious mainstream legal argument, not a fringe position from a small gun rights group. Now let me explain why the DOJ getting involved matters so much. The DOJ doesn't just wander into cases randomly. When they file in support of a constitutional challenge, it usually means the current administration has made a deliberate policy decision. It means lawyers at the highest level of the federal government have looked at the case, reviewed the legal arguments, and decided the challenge is correct. That adds enormous weight to the court's decision and to any future appeals. Because, yes, this will be appealed. These things always are. But having the DOJ in your corner changes the entire dynamic of an appeal. If you're finding this helpful so far, I want you to imagine what you'll learn in my next video. I'm going to cover the 5 specific words you should say, and the words you should never say, when police ask about your firearm during a traffic stop. That one video could literally protect you from a felony charge. Subscribe right now so you don't miss it when it drops. Now let's talk about the 20 states. Which states are we talking about, and why does it matter? When 20 states file in support of a legal challenge, it's called an amicus brief. That's just a legal term for a friend of the court statement. The states aren't parties in the lawsuit. They're saying, hey court, we want to tell you our position because this affects us too. And their message is clear. These states are saying that rifle feature bans are unconstitutional under the Second Amendment and under the Bruen standard. Some of the states filing in support include states that have their own strong gun rights traditions, states where lawmakers have been watching feature ban laws in other states and saying, we never want that here. By filing together, they're sending a unified message to the courts and to Congress that this issue matters across the country, not just in a few blue states on the coasts. Now here's what most people get wrong about this situation. A lot of gun owners hear news like this and they immediately think, great, the ban is over. I can go buy whatever I want. But that's not how it works. And if you don't understand this, you could find yourself in serious legal trouble. Here's what's actually happening right now. A court has ruled. But the ruling only directly applies within a specific jurisdiction, meaning a specific region of the country. The states with feature bans still have those laws on their books. Until a higher court, like an appeals court or the Supreme Court, makes a final ruling, or until your state legislature actually changes the law, the ban in your state is still in effect. Going out and buying a non-compliant rifle based on this ruling alone could still get you arrested and charged in a feature ban state. So please, do not make that mistake. Now, quick legal note right here. This is educational information. It is not legal advice. I'm breaking down what's happening in the courts and what it means in plain English. But your specific situation in your specific state is something you need to talk to a licensed attorney about. Gun laws vary enormously from state to state. What's legal in Texas is not legal in California. What's legal today might change next month. Always talk to a qualified attorney before you make any decisions based on legal news like this. Okay, back to the ruling. Here's the part that most other channels aren't talking about. This case doesn't just affect rifles with specific features. If this ruling holds up and gets affirmed on appeal, it could open the door to challenging all kinds of firearm restrictions that were created after Bruen without historical basis. Magazine capacity limits, certain handgun bans, even some suppressor restrictions, because the legal logic is the same. If there's no historical tradition of that specific restriction, it has a serious constitutional problem under Bruen. Feature bans are just the most obvious and immediate target. But the legal arguments being made in this case could ripple outward in ways that affect gun owners far beyond just the feature ban states. This is the part that genuinely shocked me when I dug into it. The attorneys on this case aren't just trying to win one ruling. They're laying the groundwork for a series of challenges that could reshape gun law across the country for the next generation. And having the DOJ's backing means those arguments have real institutional support behind them. Hey, a quick moment right here. 73% of people watching this video right now are not subscribed to this channel. That means nearly 3 out of 4 of you are going to miss the follow-up video where I break down exactly which states are most vulnerable to having their feature bans overturned next, and what that timeline actually looks like. Don't be in that group. Join the 50,000 gun owners who get these updates first. Click subscribe right now. It takes 2 seconds, and it keeps you ahead of every legal change that matters to your rights. Now let me tell you what happens next. Because this story is far from over, the states that have feature bans, California, New York, New Jersey, Maryland, Massachusetts, Connecticut, Hawaii, and a few others, are not going to just quietly accept this ruling. Their attorneys general will appeal. They will fight this at every level of the federal court system. The next stop after a district court ruling like this is usually the Circuit Court of Appeals. And from there, it could absolutely end up at the Supreme Court. Given that the Supreme Court already handed down Bruen and completely changed the legal standard, many legal experts believe the court could take this up again. And if they do, the outcome could be binding on all 50 states at once. Here's a hypothetical example to explain what that could mean. Imagine you live in California. You legally own a rifle, but it had to be modified to be compliant with California's feature ban law. Maybe it has a fixed magazine or a featureless stock. If the Supreme Court ultimately strikes down feature bans nationwide, California would have to remove those laws from the books. You could potentially restore your rifle to its original configuration without breaking any state law. That's not guaranteed. That's a hypothetical. But it shows you just how big the stakes are here. There's one more thing I want you to understand before we wrap up. The speed at which this is moving matters. Gun rights litigation has accelerated dramatically since the Bruen decision in 2022. Courts have been working through a backlog of Second Amendment cases at a faster pace than at any point in recent history. That means decisions that might have taken 5 or 10 years to work through the system are now moving in 1 or 2 years. This ruling today could see an appeals court decision within 12 to 18 months, and a Supreme Court ruling within 3 to 4 years. In legal time, that is fast. This information has a shelf life. Laws and court decisions are changing faster than most people realize. Subscribe right now because the next video I'm releasing goes deep on the specific timeline for this case, which courts it goes to next, what the expected rulings look like, and what you need to do to prepare in your state before this reaches the Supreme Court. You do not want to miss that. Hit subscribe before you do anything else. So let's bring it all together. A federal court just ruled against rifle feature bans. The DOJ and 20 states are backing that challenge, and the legal foundation being used, the Bruen standard, could extend this fight far beyond just feature bans to other gun restrictions across the country. But here is the single most important thing you need to take away from this video. Do not change your behavior or your firearm setup based on this ruling alone. The laws in your state are still in effect right now. Follow the law in your state until a court or your legislature officially changes it. Stay informed, stay legal, and stay patient. These things take time to fully work through the system. Before you go, do me one favor. Hit that subscribe button right now. I spend hours every week digging through court documents, legal filings, and constitutional law so you can understand what's happening in plain English. This channel exists to make sure you never get blindsided by a gun law change. The next video is going to be something you genuinely cannot afford to miss. Subscribe, hit the bell, and I'll see you there. And remember, this video is for educational purposes only. Nothing here is legal advice. For guidance specific to your situation and your state, always speak with a licensed attorney who specializes in firearms law.